Good morning and welcome to our Miller-Johnson COVID-19 update series. My name is Laurie Murphy. I'm the chair of our estate planning and private client group. And we've had a lot of questions from our clients who have elderly loved ones and are wondering a lot of things. And so we're trying to address some of the questions that we're receiving frequently and give people some resources to deal with the stress that's coming from being a caregiver or just worrying about a loved one who is particularly vulnerable to the COVID virus. COVID-19 is unfortunately disproportionately affecting older people. Older people are at higher risk due to their age, due to underlying health conditions. A lot of older people are having a harder time accessing just their regular routine medical care that keeps them healthy on a day-to-day basis. And for people who are family caregivers, and I know we have some HR directors, and I know you're seeing this, family caregivers are juggling multiple responsibilities. Maybe their daycare is canceled, they're working at home, they're trying to take care of a loved one who maybe is in assisted living or a nursing home and make sure they're doing okay. And for people who really should have been admitted to an assisted living or nursing home, people are afraid to do that because they're worried if they do that, they won't be able to maintain contact with that family member. So this is a very difficult time, a very stressful time for people. And we wanted to give people some ideas of what was going on and address some of the questions that we've had. Some key areas of concerns that we have heard in the calls we're getting are medical decision-making, financial decision-making, probate avoidance, Medicaid, and some caregiver resources and support. So let's talk about medical decision-making first. Who can make medical decisions? So again, if we're thinking about an older person, just because you're old doesn't mean by any stretch of the imagination that you're not competent. So if you are still competent, you make your own decisions. For good or for bad, you make your own decisions. Now again, for those of us who have older loved ones, sometimes you're not happy with the decisions that they make. So if you tell them not to go to the grocery store, now most of them are believing us. But a competent adult can make their own decisions about their medical care. There's also informal family decision making. If a person is married, often medical providers will look to a spouse for medical decisions if the person no longer can make their own decisions. And if there is no spouse, oftentimes medical providers will look to adult children as medical decision makers. Technically, under Michigan law, that's not legally binding. Technically, under Michigan law, a spouse has no automatic legal right to make decisions for an incapacitated loved one. Same with adult children. Children do not have any automatic legal right to make decisions for their incapacitated parents. The better way, or the most common way to give legal authority for somebody to make medical decisions is to sign a patient advocate designation. That's what Michigan law calls a medical power of attorney. You will also see them called advance directives or living wills. They're all really the same thing. It's a document where you assign somebody the right to make decisions for you if you can't make your own decisions. And if you haven't done any of those things, and if informal family decision breaks down, you may end up with a court-ordered guardianship. So a patient advocate designation, like I said, also called a medical durable power of attorney or an advance directive, can also include a living will. A living will is for end-of-life treatment. So if I can no longer breathe on my own, if I need dialysis, if the burdens of a treatment outweigh its benefits, that can be included in your patient advocate designation. Michigan doesn't have a standalone living will which says if this happens, then pull the plug. Michigan doesn't have that. Instead, we incorporate it into the patient advocate designation so a trusted decision maker can actually make that decision with all of the information available at the time the decision needs to be made. Michigan law says that a patient advocate can make those end-of-life decisions only if the document specifically authorizes it and if that decision is medically sound. So I cannot direct the medical people to pull the plug on my loved one if that's not a medically sound alternative. So if I go in for an ingrown toenail and I'm under anesthesia, I can't tell the doctors, don't wake that person up. That's not medically sound. You can also authorize mental health treatment in your patient advocate designation, but you've got to specifically authorize that. Patient advocate designation has to be written, it's got to be signed, dated, and it has to have 2 witnesses. And in this time, it's very difficult because those 2 witnesses can't be your family and can't be your medical providers. And right now, with everybody on the stay-at-home order, pretty much the only people you're going to see is your family and your medical providers. Until May 6th, maybe, and it maybe will be extended, the executive order allows remote witness and notary. So you can have a Zoom meeting or in some circumstances a FaceTime meeting. So a meeting that allows the person acting as witness or notary to look at the person signing, to actually see them signing, and then to sign as a witness later on. So that's an option that is very helpful for people who are locked down right now. The patient advocate designation only applies when you can't make your own decisions. So as I said before, if you're competent, you make your own decisions. The patient advocate designation only applies when you can't make your own decision. Michigan law provides for very broad powers to be granted for a patient advocate. So it isn't just for end-of-life decisions. It could be for decisions about whether you want to be enrolled in a clinical trial, whether you want a second opinion from a university medical center, whether you should be placed in assisted living or receive care in a different setting, whether you should receive one set of medications with particular side effects or a different set of medications with particular side effects. So the idea is that your patient advocate steps into your shoes and follows your wishes with regard to your medical care. So one of the important things to think about is you have to talk to your loved ones while you're still competent so they understand what your wishes are. So for medical decision-making, as I mentioned before, Michigan does not have a separate standalone living will for end-of-life decisions, but those instructions about end-of-life decisions can be included in your patient advocate designation. One other document is called a do not resuscitate order. So if you're in the hospital, you will, or your loved one will be asked, in the event that your heart stops and you stop breathing, do you want to be resuscitated? And so that would be CPR, it would be going on a ventilator, those sorts of things. So do you want to be resuscitated? In the hospital situation, the doctors will actually enter a medical order in your chart. But what if you are in a situation outside the hospital? What if you're in assisted living? What if you're in a home and you have home health care? What if you are in a nursing home and you don't want the ambulance people to come and break your ribs and drag you to the hospital, and you do not want to be resuscitated in that out of the hospital situation? Michigan allows you to sign a do not resuscitate order under the Do Not Resuscitate Procedures Act. That document has to be signed by you or your patient advocate and your physician. So that's different than your patient advocate designation. It's kind of a one step further for the absolute end-of-life situation. You might have to get involved with a court-ordered guardianship if you don't have appropriate decision makers in place. So if you have no decision maker, if you have no informal decision maker, if there's disagreement among informal decision makers, or if there's decisions that have to be made beyond emergency care. So an example of that would be my father got sick, he ended up in the hospital. From an informal decision maker standpoint, our family was able to agree about his emergency care, but now the hospital wants to discharge him, and there's nobody that has the authority to sign him into a rehabilitation setting or some other situation. So that would be an example of where a court-ordered guardianship may end up having to be required. So what if medical care is needed for an elderly loved one? And I know that you've seen a lot of these things out there on the internet as well. I'm just trying to summarize them, so there are good materials out there. So the first recommendation is to call the primary care doctor first and find out what the alternatives are, what the doctor is recommending with regard to testing, treatment, whether this may be symptoms caused by a pre-existing medical condition, whether the doctor might be able to do a telehealth visit. So all of those things are the first starting point. So call your doctor first. If COVID is suspected, the Kent County Health Department website has testing criteria, information about making appointments, and other information about how you would go about getting tested, or if you're in a very serious situation, then you can just go straight to the emergency room and they have a process there. But even there, if you call first, so Spectrum has a number, Metro has a number, St. Mary's has a number, you can call and they will tell you what their process is going to look like. Some things to be aware of is that the caregiver may not be able to accompany their elderly loved one to the hospital, and this is heartbreaking for many people. They may be permitted to attend an emergency room intake, which is helpful because a lot of times if you've got an elderly relative, they may have difficulty hearing, they may have difficulty with cognitive impairment, and it may be very difficult for them to provide an accurate history or information. But just be aware that you may or may not be able to attend an emergency room intake, but once the intake occurs, you may not be able to stay with your loved one. So plan on having kind of a go bag. So bring a phone for that person if they're able to use a phone charger, a list of family contacts, because if you're ill, you're not necessarily going to be able to remember everybody's phone number. If your loved one has dementia or cognitive impairment or a hearing disability or is blind, you may want to advocate right from the beginning for additional attendance or services, because this person is not only ill, they're going to be very confused, scared, and how do you make sure if you're not there to watch over them that somebody's taking care of them? Again, what if your senior needs medical care? Some things that you may want to think about would be to scan all of their relevant documents onto your phone and maybe onto their phone. You could just put them on a document app. You could email them. So what kinds of things should you scan? If they have a patient advocate designation, a medical power of attorney, an advance directive, if they have those documents, scan those. The insurance card and picture ID are very helpful to have electronically in case, again, they don't make it with your loved one into the emergency room or into whatever medical setting that they're going to. A summary of medications, doses, and allergies. That can be handy to have. Medical history, surgeries, and contact information for your primary care physician for your loved one. A scanning app that we've been using is called Genius Scan. It turns documents that you scan into a PDF, and we've had very good luck with that. But you can simply take a picture with your phone and just have it in your photos. That's another alternative. You could email it to yourself. I'm sure there's other more sophisticated apps out there, but I'm not very sophisticated on the app department. Now that we've had this Executive Order 2020-37, people who are in assisted living, nursing home, other healthcare facilities are locked down for their safety and for the safety of their caregivers. That has been heartbreakingly difficult for many people. And so what that executive order says is that the facility must prohibit entry of visitors that are not necessary for the provision of medical care, the supportive activities of daily living, the exercise of power of attorney or court-ordered guardianship, and are not visiting an individual that is in serious or critical condition or in hospice care. So how this has been interpreted is unless the person is at the very end of life, or unless there is some extremely important reason that you have to be physically present to your loved one who is locked down, you will not be able to see them. And that is very difficult And so I have some ideas on how you might be able to deal with that. So what if medical care is needed for a person who is in a facility? And how are you going to know that they even need medical care? Now, most people who have loved ones in facilities are having very frequent contact by phone, by peeking through the window, by updates from the nursing staff. But what if you hear that your loved one is ill? What should you do? Or what should you do before you find out that they've been diagnosed with COVID or with any other emergent situation? So our experience has been that most of our local facilities have done a great job of developing a COVID-19 plan, that they've developed training materials, they have upgraded their staffing. So find out what the facility where your loved one is living has done in terms of their COVID-19 plan. Most of them have spent a lot of time doing the planning, doing the training, doing the staffing, and not all of them have communicated that good job to to their residents' families. So my guess is that if you ask, they will tell you they have a plan in place, and if you ask for that plan, they will provide more information for you. If your loved one can't communicate well, you may want to ask for case notes or a daily FaceTime with your loved one and one of their caregivers. If your loved one does become ill, you have to advocate strongly, even if remotely. Again, your facility's COVID-19 plan may provide for a point person. If it doesn't, you should immediately request contact with the director of nursing, with the facility physician, or again, if the facility plan provides for a point person, figure out who that point person is and how you can reach them at any time. Your facility's COVID-19 plan is likely to have some kind of criteria for transfer to hospitals, and if you think that your loved one's not getting what they need, you're going to need to advocate for testing or additional care or assistance if needed. And again, facilities are doing their very best with sometimes limited staffing. They may have staff members who've been exposed or who are sick themselves. So it may need some additional patience in terms of trying to contact the facility, trying to deal with staff people. So be patient, be persistent, and advocate as much as you can. If your loved one is transferred to a hospital or to a facility's dedicated COVID-19 unit, find out what is the facility's plan for keeping the family informed about where that person has been transferred, how are they doing, and how to reach somebody who can provide ongoing updates. What is the facility's plan for reducing confusion and disruption for a person with cognitive impairments? And then just the dumb day-to-day stuff. How are we going to keep track of their clothing, their dentures, their glasses, their hearing aids? Most of the facilities have developed plans for this, but what you will see is if your loved one develops COVID-19 or if someone else in the facility develops COVID-19, facilities are being allowed to have a segregated unit where they move people to keep them isolated and safe. So under Executive Order 2020-550, the state has put together a process for managing people who are stable but do have COVID-19. So these rules are if the person has COVID-19 and the facility has less than 80% occupancy, they have to create a separate unit, or if they're a chain, a separate building as a COVID-19 facility. So then if a person is diagnosed with COVID-19, they get moved to that unit or facility. If there's no dedicated unit or if there's insufficient personal protection equipment, that person who has been diagnosed might be sent to a regional hub. So a regional hub would be a facility that has agreed to accept patients from other people's residential settings and then take care of them. If there's no hub and a person is ill, even if they're stable, they may be sent to a hospital that has capacity to take care of them. And if there's no hub or hospital, that resident might be transferred to an alternate care facility. Now in West Michigan, we are nowhere near a situation where we have insufficient capacity. So at this point, what we are seeing is that people are being segregated within their same facilities. They haven't typically been transferred around, and we certainly haven't reached a situation where an alternate care facility has been needed. You've seen that over more in the Detroit area where Cobo Hall or places like that have been repurposed as an alternate care facility. If the resident becomes unstable, so unstable means, for example, they just can't breathe on their own, they have to be transferred to the hospital unless there is an advance directive to the contrary. So if they have a patient advocate designation with a do not resuscitate order, or there is an advance directive that specifically states they do not want to be taken to the hospital, that is enforceable. But without that, the person must be transferred to get care in a hospital setting. So most people who are getting sick and who are going to the hospital, even older people, are getting better, and that is great news. So how do you get that person transitioned from the hospital back to the facility? If the original facility has a dedicated COVID unit and they have capacity, the resident returns back to their original unit. If not, the hospital may discharge that person to a regional hub that has capacity. And again, if the hub's not available, that resident could be transferred to an alternate care facility that does have capacity. And again, we're not seeing that in West Michigan at this point, but I know that we have read stories of people being transferred to hotels or other alternate care facilities. The alternate care facility is really not intended to be a long-term solution. And again, these are older people who need help a lot of times. And so the idea is that the person will be returned to their normal residence as soon as capacity allows. And if there isn't capacity, then they should, again, be transferred to a regional hub. And the idea is that we all want to get everybody transferred back to their normal setting as soon as possible once they recover. So what are some frequently asked questions that we're seeing? So can I get into the facility to see my loved one? And the short answer to that, sadly, is no, unless there's an urgent reason because the person is at the very end of life and you request a compassionate visit. For the safety of everybody else involved, they are really saying, no, you can't get into your facility to see the loved one. Most nursing homes are doing a great job of arranging video conferencing, phone calls, window visits. So talk to the facility and see what they can help you do to see your loved one, to lay eyes on them and check on their well-being. What if you want to take a loved one home? So some people are saying that they just can't bear the thought of their loved one staying in a facility and not being able to have contact. So can you take your loved one home? So the answer to that is yes. So let's think about that though. If your loved one can make a choice to leave the facility because it's a residential facility, they're still a competent person, then they can make their own decision about whether they want to come home or come to your home. So think hard though about whether your loved one's needs can be met at home. Think about who's going to be the primary caregiver and think about a backup if the primary caregiver gets sick. Are there procedures like catheterization, blood sugar monitoring, wound care, bathing, things that would be very difficult for you to handle if you take your loved one home? And how is that going to affect all of the rest of the people who may be sheltering in place at your home? So be very realistic about the idea of taking a loved one home. A colleague of mine has a father who's actually on hospice, and he is in a facility over in the Flint area. The family's decided that two family members, a daughter-in-law and a daughter, are going to bring him home to the daughter-in-law's home. They're going to provide the care for him, and they think that's the right thing for them to do. And so for some people, that will be the right thing to do, but try to be realistic about how hard that's going to be on everybody. The next question is, if you do take your loved one home, will the nursing home take him or her back after that crisis is over? So they may not be willing to take you back. So be aware that if you take a loved one home, you may have to go through a whole new process of finding a placement. How do you find out if anybody in your loved one's nursing home has COVID-19? Well, check their website, ask their executive director, and there is some limited information on the Michigan COVID website, but just be aware it may not be up to date. And I've shown the general Michigan COVID website there. If you search for Michigan COVID and nursing home, you will find a list, but again, be aware it's not 100% up to date. Some more frequently asked questions. What if the nursing home calls and says that your loved one's being discharged to another nursing home? Can they do that? So yes, they can if the reason for discharge is related to whether or not the person has COVID-19. So if they're being discharged either because they are negative and other people in the facility are positive, or if they are positive for COVID-19 and other people are negative, they could be discharged to a different setting, again, because of the COVID crisis. But otherwise, a discharge can't occur without the normal process of notice and right to hearing if it's unrelated to COVID-19 status. So what if your loved one goes into the hospital and then the nursing home won't take that person back? Can they refuse? And the answer is, if it's related to COVID-19, the answer is probably yes. What do you do if your loved one's Medicaid renewal is due, but you can't get all the required information? Can they be discharged for non-payment? The answer to that is no. Now, with the Medicaid renewals, what we are trying to get people to do is do the very best they can to gather information online with phone calls, again, with scanning apps, and submitting that so that you can keep things on track, because eventually you will have to get those renewal applications put together. But for now, Medicaid is putting a pause on kicking people off Medicaid who, for whatever reason, can't get their documentation in. It does not, though, apply to people who are initially applying for Medicaid. People who are initially applying for Medicaid are not getting any breaks in terms of their ability to continue to apply. If you work with an elder law attorney, they typically can walk you through that process, and we are still getting good responses from the Department of Health and Human Services in assisting people who are actually applying for initial Medicaid. Let's talk about financial management. So if your loved one is unable to take care of financial matters, how do you do that for them? So they're alive, but they can't take care of things for themselves. Well, if you are a joint owner on their bank account, each and every joint owner of a bank account is considered the owner of the entire account. So you could access that account and use it to pay the bills for them. Things like IRAs, annuities, life insurance, and other beneficiary designation assets can't be jointly owned. So a joint owner cannot take care of those kinds of things. And you should be aware that a spouse has no automatic right to act on assets other than jointly held assets. Most people should have a durable power of attorney. Again, it's a written document. It remains effective even if you become incapacitated, and it can be used to avoid a probate court conservatorship. The powers in the power of attorney are generally limited to those that are specifically mentioned in the document. So a document that says, my power of attorney can do everything I can do, probably means they can't do much of anything because you haven't specifically mentioned which powers they can exercise. It can be effective immediately, or you can require proof of incapacity. It has to be witnessed or notarized, and at least until May 6th, and maybe that will be extended, it can be done remotely under that temporary executive order. So if you want to do a durable power of attorney, or if your loved one is stuck in a facility and wants to do a power of attorney, assuming that they're still mentally competent, we can do that with that remote witness and notary process. It's kind of unwieldy, but it's very doable. So what can you do now? So again, think about signing a durable power of attorney now. Remember that the person who was appointed is accountable to you and to other family members. If you have a durable power of attorney, your decisions still trump the decisions of the person acting under your power of attorney, and you can change or revoke that power of attorney at any time as long as you're competent. Another set of questions we are getting is, because we do have older people who are at additional risk not only of getting sick, but sadly of passing away. so people are asking us about avoiding probate. So what in the heck is probate? So probate is a court-supervised procedure to transfer assets from the name of a deceased person to who's ever supposed to get those assets. Probate applies to assets that are in a deceased person's name alone, without a joint owner, without a beneficiary, or without other statutory or administrative means of accomplishing a transfer. A will does not avoid probate. A will is just an instruction manual for the court to use in terms of how those assets should be distributed once probate starts. So why do people want to avoid probate? It can be time consuming. It can be deadline sensitive. So once you file all the paperwork with the court, which you can do by yourself, but it's very difficult to do without a lawyer. You have 10 days to do certain things, 60 days to do certain things, 90 days to do certain things. And so that deadline sensitivity can be stressful on the family. It can be expensive. It's a public forum where your will becomes a matter of public record, and it's an easier forum for people to complain. So it's easier for somebody to complain about not getting something under a will because there's already a process in place. Versus if you have a trust or other non-probate transfers, the person who wants to complain has to actually start a court proceeding rather than just joining one that's already in process. What are non-probate assets? So there are a lot of things that pass outside the probate court process. So for example, assets with a beneficiary designation pass to the named beneficiary regardless of what your will or trust provides. Joint assets also pass to the surviving joint owner regardless of what your will or trust provides. Statutory or administrative provisions. So for example, your final paycheck generally passes to particular listed people, typically your spouse, your children. Your car can be transferred through the Secretary of State's office without probate by using certain processes. If you want to control where everything goes and you don't want to rely on those default provisions, a trust is the most common way that people will avoid probate while also having a high degree of control on how their assets are administered after their death. A ladybird deed is another example of a probate avoidance technique. It is like a beneficiary designation for your house. So you name a beneficiary, the ownership doesn't change till your death. You have the right to revoke it. It's a good thing because it's not a divestment for Medicaid. So a ladybird deed can be a probate avoidance technique. A transfer on death or pay on death designation on a bank account or a brokerage account avoids probate. A beneficiary designation on life insurance or retirement plans avoid probate. Joint ownership generally avoids probate, but there are some exceptions. And so with all of those things, other than a trust, what it doesn't do a good job of is contingency planning. So if I name my child or my 3 children as beneficiary on my life insurance or my retirement plan, what if one of those children predeceases me? What these default provisions, these transfer on death, don't do a good job of handling is the what if. What's the contingency plan if my initial plan doesn't work out? So for most people, a will or a trust does a better job of making sure that your assets go where you want them to, but sometimes probate avoidance through some of these other techniques can be very helpful. Other questions we are getting are about Medicaid qualifications, because as people are facing reductions in the amount of assets they have and their ability to privately pay for the care they need, Medicaid may be a source of payment for long-term care expenses. So Medicaid says that there are very specific requirements. So not everybody qualifies for Medicaid. So Medicaid, first, you have to meet asset and income requirements. You have to be in a qualified setting, so typically in a skilled nursing facility, or if you are in assisted living, you may qualify for something called Medicaid waiver, which is a different Medicaid program. Medicaid exempts certain assets. I just noticed a typo in my materials. So a homestead is generally exempt. If you have it in the name of your trust, you have to take it out of your trust before you apply for Medicaid. 1 car per family is exempt for Medicaid purposes. Household goods and personal effects are exempt, and certain assets that are unavailable may be considered exempt. Qualified funeral and burial arrangements are exempt, but not all burial and funeral arrangements are exempt. So again, you'll have to consult with an expert elder law attorney to figure out which of those exemptions may apply. Everything else is counted. So if you're a married couple, be aware that prenups are not respected and assets of both spouses are counted. Countable assets include joint property, real estate other than a home, cash value of life insurance, boats, motorcycles, cars other than your one exempt car, RVs, IRAs and retirement plans are counted, bank accounts are counted, securities are counted. Pretty much everything other than those exempt assets are counted. And some things are particularly tricky because you wouldn't necessarily think about how they would be counted, or they're counted in a way differently than you would guess. So land contracts are counted, and they are treated as income to the extent that you receive land contract payments, and they're also treated as an asset to the extent of the outstanding balance. LLC interests or family business interests are countable. Interests in family cottages, hunting cabins, recreational properties are counted. Assets in revocable trusts are counted. So most trusts, unless they're irrevocable, unless you can't revoke them or change them, those are counted. Assets in those trusts are counted. Annuities are countable. Joint property with other people is countable. So those can be tricky, but be aware that if you're trying to qualify for Medicaid, Medicaid throws a broad net to determine exactly what you have before it determines whether you meet the qualification requirements above and beyond your exempt assets. Medicaid also has divestment penalties for things that you have done in the past. So what you've done in the past will affect your future Medicaid eligibility. There's a 5-year look back, and so the penalty starts only after you've been approved for Medicaid, but for the divestment. So the more you give away, the longer you will be in the penalty box after you run out of money. So Medicaid says that divestment is any uncompensated transfer for less than fair market value unless an exception applies. So gifts to family members are generally going to be treated as divestment, even if it's less than that $15,000 per person per year IRS annual exclusion amount. Medicaid generally counts a gift to a family member. Anything more than $100 is going to count as a divestment. Even gifts to charity can be considered divestment. Paying your kids' bills is a divestment. So if a parent pays the child's mortgage or pays their lawyer bill or pays their child's tuition, all of those things are going to be considered divestment and may affect the parent's eligibility for Medicaid for the next 5 years. Adding a child to the deed to your house is considered divestment, or adding a child to your brokerage account is considered divestment. Loaning money that you know is not going to be paid back is also considered divestment. So again, Medicaid throws a very broad net. Purchasing an annuity that doesn't meet Medicaid's strict requirements can be a divestment. Giving away assets, even exempt assets, like a house or a car. Paying somebody to provide care. Now that's where if you bring your loved one home and you're providing care, it is absolutely fair that you would get compensated for that. But if you don't have a Medicaid qualified care contract in place, Medicaid is going to consider any payments provided for care as divestment. We mentioned the difference between a revocable trust, which has countable assets, and an irrevocable asset protection trust. If you put assets into an irrevocable asset protection trust, there's going to be a 5-year penalty look back on that transfer to the asset protection trust. Not everything is a divestment, so certain transfers are not divestment. So those would be purchases of goods and services. So if you pay your lawyer, that's a purchase of a good or service, so that is not divestment. Paying for caregivers to come to your home, paying your utility bill, paying your mortgage, those are not divestment because you're paying for goods and services. Just paying your normal bills for the applicant or the spouse of the applicant, not divestment. Purchasing exempt assets, so if you buy a car, if you buy prepaid burial arrangements, That is not divestment because you're purchasing an exempt asset. Paying down your mortgage or paying other debt. Any transfers between spouses are not considered divestment. And purchasing Medicaid qualified annuities, very specialized kind of annuities, generally not considered divestment. There are also planning techniques that you can use where assets are transferred to a trust for the sole benefit of a spouse, a transfer to a disabled child who's disabled under the Social Security Act, or certain kinds of special trusts for the benefit of a person with a disability. So not everything is a divestment, but a lot of things are. So again, if you're thinking about making a gift, or if your loved one is thinking about making a gift, make sure you consult with an elder law attorney about how that might affect your eligibility for Medicaid in the future. For a single person, Medicaid says that the person can have $2,000 in non-exempt countable assets. So remember, everything counts. Cash value of life insurance counts. Your interest in the hunting cabin counts. So what do you do with those excess assets? You can pay off debt. You can purchase exempt assets. You can buy a funeral arrangement. You can buy a car. You could buy a wheelchair, dentures, hearing aid. You can purchase goods and services. So there are a lot of things you could do to spend down excess assets. For a married couple, the rules are much, much more complicated, but much more protective of the spouse who's not in the nursing home. So Medicaid basically says that the spouse who's not in need of Medicaid assistance can keep half of the couple's countable assets as of their first day of initial assessment. So that would be the first day of institutional care in a hospital, rehabilitation facility, or nursing home, or the date of a level of care determination for My Choice waiver or PACE. After that determination is made, the spouse is entitled to keep half of the countable assets up to a maximum of $128,640. There's also a minimum of $25,728. And again, remember that prenups are ignored in this. So for a married couple, the first step is to establish that initial assessment date, that how much is my total pot that I divide to determine what I get to keep half of. Then paperwork is filed with Medicaid showing all of the assets as of that initial snapshot date, that first day of long-term care, that first day of the level of care determination by Medicaid waiver or PACE. Then assets are either spent down or sheltered, and again, there are many techniques that can be used to protect a spouse if one of the spouses needs long-term care and the other one does not. Then the Medicaid application is filed. Then the spouse who's not in the nursing home needs to move all the assets into their own name, and then rinse and repeat. Every year you've got to redo the Medicaid application. Again, there are many techniques that can be used to protect assets and to save particularly spousal assets, to take good care of a spouse. So a lot of what you read on the internet is not necessarily applicable because every single state has different rules about what you can and can't do. So don't try this at home. So an example would be for a married couple, if on that first day of long-term care or that initial assessment date or level of care determination for Medicaid waiver, if that couple had $100,000, the spouse who's not in the nursing home or who's not in need of Medicaid would keep half of that pot, $50,000, plus the $2,000 that the nursing home spouse is allowed to keep. And then I've got in the other box some examples of what could be done to spend down. The house could be repaired, funerals could be purchased, all living expenses of both spouses could be paid, a car could be purchased. And again, there are trusts and other techniques that can be used to protect a spouse from impoverishment. If you had a couple with more assets, again, there is a maximum. So if a couple had $300,000, then the spouse who's not in the nursing home would get to keep that maximum amount and would have to spend down the remainder. And again, in a situation like this, there are many alternatives that can be used to protect assets for the spouse who is not in need of Medicaid assistance. If you're applying for Medicaid, again, it is much more complex than you would think. So it's a short form, but there are a lot of pitfalls in that form. So typically the 6 or 8 page form really is a 2 to 4 inch pile of paperwork that gets scanned in and sent to Medicaid, and every single thing has to be proven So if you don't have a birth certificate, you weren't born. If you don't have a marriage license, you weren't married. If you don't have a Social Security card, you don't exist. So you need to have a lot of documentation to prove to Medicaid that you have eligibility. And again, it's a fair system. The idea is that we want to help people who are genuinely in need of help, but we don't necessarily want to subsidize people who are simply wanting to leave a large inheritance to family members so that the taxpayers have to pay their bills. So in conclusion, I've got some community resources here that you might find helpful, and you should feel free to share. The Area Agency on Aging of Kent County or of West Michigan has some outstanding resources. They will provide information about everything from home delivered meals. They have a phone visitor where they can do a daily checkup on a caregiver or on a loved one. And for people who meet their qualification requirements, they have people who can actually deliver essential items to your loved one that can provide some relief or respite for caregivers. So they provide information and referral. There's information on their website, and there's information if you call them. The Caregiver Resource Network is an outstanding resource that was originally developed in Kent County and is actually used in a lot of other areas now. There are videos about caregiving, about proper lifting. There is caregiver support. There are resources, just tons of fantastic information on that Caregiver Resource Network. The Heart of West Michigan United Way has a lot of resources, including information and referral. If you call 211, they can try to put you in touch with local resources that could be helpful. And I put a link to their coronavirus update resource page, so you can link there. Now, on the bottom, I'm sorry, I didn't include the Michigan Elder Justice Initiative is that last one. Sorry, I didn't include that. They are a very helpful group that can provide advocacy, and I have attached to this outline, they've put together a very nice flow chart about what happens to people who are in institutional settings when they either get COVID or somebody else in their facility gets COVID. What is the process of figuring out where they should go, where they have to go, where they must go, what are their rights around that? So that Michigan Elder Justice Initiative is that last bullet point. And I've attached to the outline a great piece, a great flow chart that they have prepared. So in closing, I want to tell you, you are not alone, and your community is here to help. And again, I know that some of the people on this call are HR directors, and I know you are doing your very best to find ways to help your employees who are struggling dealing with elder law issues for their loved ones. So please do feel free to share these resources with them. If you are a caregiver, take care of yourself. Like they say on the airplane, put your own oxygen mask on first before you try to help others. If you can't take care of yourself, if you get sick, if you get run down, if you develop severe depression or anxiety, that's not helpful to the loved ones that you're trying to take care of. Do what you can when you can. And if you can't do it all, that's okay. Just do the best you can. And try to be gentle with yourself and others, and that includes the employees of the facilities that are trying to take good care of your loved ones. Everybody's overwhelmed at this point. Everybody's struggling at this point. So try to exercise as much patience as you possibly can. Reach out before you reach your limit. There are resources there, and we are here to help. I appreciate your time on the seminar today. Because I'm doing this solo, I didn't have a chance to address any questions that may come up, but please do feel free to submit your questions, and I will try to answer them as best as I can. I wish you all the very best. I hope that everyone is staying safe, healthy, and at least a little bit sane. Thank you so much for your time, and our seminar is over. Thank you.